On January 30th, 2026, the United States Department of Justice committed what attorneys would call the single most egregious violation of victim privacy in American history. Over 3.5 million pages of secret documents related to the Jeffrey Epstein case were dumped into public access. But instead of the promised transparency, something monstrous occurred. The names and personal information of dozens of surviving women were left unprotected and accessible to anyone who wanted to find them. Meanwhile, the names of those who helped the convicted pedophile find new victims, who organized meetings, who knew and stayed silent. These names were hidden behind thick, black rectangles. The system protected the powerful and threw those who had already suffered once to the wolves. The scale of the release is staggering. Imagine a stack of paper as tall as 2 Eiffel Towers. That's exactly how Deputy Attorney General Todd Blanche described the volume of published materials. Within this mountain of documents were more than 2,000 video recordings and 180,000 photographs. The Department of Justice claimed it had enlisted over 500 lawyers and specialists to review the documents before publication. These people worked for 60 days straight, examining every page, every image, making decisions about what to hide and what to show the world. And here's the result of their work. The documents contain detailed testimonies from women about how they were assaulted as teenagers. Their full names are there, addresses, phone numbers, intimate details of their personal lives. One survivor discovered transcripts of her confidential conversations with FBI agents in the public domain, where she described in excruciating detail the abuse she endured. Another woman, who had never publicly come forward with accusations, suddenly found herself identified in the documents. Her attorneys claim the client didn't even know these files existed until their publication. Meanwhile, a draft indictment against Epstein, dated from the 2000s, contains descriptions of actions by several individuals who allegedly helped him in his crimes. The document accuses them of conspiracy to persuade, induce, and entice minors to engage in prostitution. All these people are described as facilitators of meetings between Epstein and girls. But here's the paradox. Every single name on this list has been replaced with a black rectangle. We know what they did. We know what they were accused of, but we don't know who they are. Moreover, among the published materials, an 82-page document was found relating to Epstein's psychological evaluation. This could have shed light on the personality of a man who created an entire network of sexual exploitation of minors. But out of 82 pages of this document, 81 are completely redacted. The reader has access to only one page, probably a cover sheet with a title. Everything else that could explain how psychologists assessed this person, what conclusions they reached, what danger he posed to society, all of this remains hidden. Another 7-page document was found completely redacted and later appeared to have been removed from the Justice Department website entirely. Not a single word visible, just black rectangles on white background, page after page. What was in it? Why was it published if everything was hidden? And most importantly, why was it then quietly deleted, as if hoping no one would notice? Congressman Ro Khanna, a Democrat from California, and Congressman Thomas Massie, a Republican from Kentucky, who led the bipartisan effort to pass the law requiring the DOJ to release these files, sent a furious letter to the department. They wrote that they had seen a blanket approach to redactions in some areas, while in other cases, victim names were not redacted at all. They demanded access to unredacted documents, stating that Congress cannot properly assess the department's handling of the Epstein and Maxwell cases without access to the complete record. The inconsistency of the redaction approach is truly shocking. The same PowerPoint presentation prepared by the Justice Department detailing the timeline and cases against Epstein and Maxwell appears 6 times in the repository, with different levels of redaction in each version. In one version, certain names are visible. In another version of the exact same presentation, those same names are blacked out. In a third version, different names are redacted while previously hidden ones become visible. It's as if different people made decisions about what to hide without coordinating with each other. But perhaps the most disturbing discovery lies in how images and videos were redacted. Deputy Attorney General Blanche stated in his announcement that the department redacted every woman depicted in any image or video, with the exception of Ghislaine Maxwell. He claimed they did not redact images of any men unless it was impossible to redact the woman without also redacting the man. This sounds reasonable in theory. Protect the victims, show the perpetrators. If you're shocked by what you've learned so far, this investigation goes much deeper. Subscribe to stay informed as we uncover more details about one of the biggest scandals in American justice. Hit that like button if you believe victims deserve better protection, and leave a comment sharing your thoughts on this massive failure of the system. However, the reality in the published files tells a completely different story. Multiple examples can be found where faces of women are clearly visible while faces of men are hidden. The Department of Justice claimed in its letter to Congress that it identified more than 6 million pages of potentially responsive documents during its review, but a large number of those were duplicative. Approximately 200,000 pages were redacted or withheld based on various privileges, such as attorney-client privilege or deliberative process privilege. Documents in foreign languages or that could not be uploaded for review due to technical issues were also not produced. This explanation raises more questions than it answers. If 200,000 pages were withheld based on privilege, what privilege protects the identities of people who allegedly helped a convicted sex offender find victims? Attorney-client privilege applies to communications between lawyers and their clients, not to evidence of crimes. Deliberative process privilege protects internal government discussions, not information about private citizens who may have committed crimes. The law that mandated this release, called the Epstein Files Transparency Act, was signed by President Trump on November 19, 2025. The act required the government to release all of the Justice Department's files in relation to the Epstein case within 30 days. It also requires the Trump administration to explain any redactions to Congress. The government missed the December deadline, citing the complexity of the review process. Trump himself had a complex relationship with Epstein. They were neighbors in Palm Beach for years, both owning estates in the exclusive Florida enclave. They attended parties together in the 1990s and early 2000s. Photographs show them laughing together at Mar-a-Lago events. Trump was quoted in a 2002 New York Magazine article calling Epstein a terrific guy, and noting that Epstein likes beautiful women as much as Trump does, and many of them are on the younger side. However, Trump has stated that he later had a falling out with Epstein and banned him from Mar-a-Lago. The exact timing and reason for this falling out remain disputed. Some reports suggest it occurred after Epstein allegedly made inappropriate advances toward a young woman at the club. Trump has denied any knowledge of Epstein's criminal activities and has never been accused of wrongdoing in connection with the case. During his 2024 presidential campaign, Trump suggested he would seek to open more government files on Epstein if elected. This promise appeared to appeal to voters curious about the case and suspicious of government secrecy. After his inauguration on January 20, 2025,
Attorney General Pam Bondi made statements suggesting that more transparency was coming. In February 2025, Bondi appeared on Fox News and suggested that an Epstein client list was sitting on her desk. This claim generated massive media attention and public interest. However, the Justice Department later distributed binders marked declassified to certain media personalities, but much of the information in those binders had long been public. It appeared to be more of a publicity stunt than genuine disclosure of new information. The disappointment grew when, on July 7, 2025, the Justice Department announced that Epstein didn't maintain a client list and that it wouldn't make any more files related to his sex trafficking investigation public. This directly contradicted earlier suggestions from Bondi and Trump about forthcoming transparency. The claim that no client list existed struck many as implausible, given Epstein's methodical documentation of his activities. Then, on July 15, 2025, Representatives Ro Khanna and Thomas Massie introduced bipartisan legislation forcing the issue.
The Epstein Files Transparency Act passed with overwhelming support in both chambers of Congress, demonstrating that curiosity and concern about the case transcended party lines. Nobody wanted to be seen as protecting Epstein or his associates. But when the files finally came, they brought more frustration than clarity. Attorney Brittany Henderson, who represents multiple Epstein survivors, wrote in a letter to the judge who presided over Epstein's case that the Department of Justice had committed what may be the single most egregious violation of victim privacy in one day in United States history. She documented thousands of redaction failures affecting nearly 100 individual survivors. Henderson told NBC News that victims' identities remained publicly accessible days after the release, despite assurances from the Justice Department to fix the problems by noon on a specific Wednesday. For 5 days, the Department of Justice left the survivors of Jeffrey Epstein publicly exposed, named and personally identified on the government's own website, she stated, despite the department acknowledging that these disclosures were wrongful and agreeing to correct them. The Justice Department responded that it takes victim protection very seriously and has redacted thousands of victim names in the millions of published pages. A spokesperson noted that hundreds of reviewers had been scouring the documents and that in some cases, already published documents were being removed to fix redaction problems. The department also stated that as soon as a victim raises concerns about a document, the file is removed from the site so the department can decide whether further redactions are needed. But this reactive approach offers cold comfort to women who have already been exposed. Once information is on the internet, it spreads. People download files, share them, archive them. Even if the Justice Department removes a document from its official website within hours, that document has likely already been copied and distributed across multiple platforms. The damage cannot be undone. One survivor, named Danielle Bensky, who was a teenage ballerina when Epstein allegedly abused her 2 decades ago, found her confidential conversations with FBI investigators included in the document dump. She told NBC News that at first she thought it was carelessness, then incompetence. But now it feels a bit deliberate, she said. It feels like a bit of an attack on survivors. Bensky's progression of thought mirrors what many observers have wondered. Could this really be accidental? 500 lawyers working for 60 days somehow failed to properly redact victim information while successfully hiding the names of alleged co-conspirators? The pattern seems too consistent to be mere oversight. When the same type of error, exposing victims while protecting powerful people, happens thousands of times, it starts to look less like a mistake and more like a choice. Another survivor, Charlene Rochard, told CNN that publishing images of victims while shielding predators is just a complete failure of justice. There's this deep sense of betrayal when the systems meant to protect you become the one causing all of this harm, she said. Her words capture the profound disillusionment felt by women who cooperated with law enforcement for years, who testified, who relived their trauma in interviews and depositions, only to see the government they trusted betray them in the most public way possible. The question that haunts this entire release is simple. Why? Why hide the names of people accused of serious crimes while exposing the names of people who committed no crime and suffered terrible abuse? The Justice Department has offered only technical explanations about privileges and review processes, but these don't address the fundamental moral failure at the heart of this disaster. Deputy Attorney General Blanche appeared on Fox News and attempted to defend the department's work. "You're talking about pieces of paper that stack from the ground to 2 Eiffel Towers," he said. "The minute that a victim or their lawyer reached out to us since Friday, we immediately dealt with it and pulled it down." This response essentially admits that the department relied on victims themselves to identify failures in protection of their own privacy, a shocking abdication of responsibility. The files reveal extensive communications between Epstein and numerous powerful individuals, but the context often remains murky due to redactions. We can see that meetings were scheduled, that gifts were exchanged, that relationships existed. But the substance of many communications is hidden. What were they discussing? What were they planning? What did they know about Epstein's activities? In one email visible in the files, someone with a redacted name wrote to Epstein about a young woman, stating, "And this one is, I think, totally your girl." The implication is chilling. Someone was apparently helping Epstein identify and recruit potential victims. But we don't know who sent this email. We don't know if this person was ever questioned by investigators. We don't know if they faced any consequences. This pattern repeats throughout the documents. Tantalizing fragments of information that suggest criminal activity by unnamed individuals. References to arrangements being made, to girls being brought to locations, to payments being processed. They were preparing to bring charges that could have resulted in Epstein spending decades in federal prison. And then, inexplicably, they made a deal. In 2007, federal prosecutors were ready to move forward with serious charges against Jeffrey Epstein. The evidence was substantial. The victims were willing to testify, and the case appeared strong. But then Epstein's legal team, which included some of the most expensive and connected attorneys in America, began negotiations with the U.S. Attorney in Miami, Alexander Acosta. What followed would become one of the most controversial prosecutorial decisions in modern American history. The negotiations stretched over a year. During this time, Epstein's lawyers employed every tactic available to them. They attacked the credibility of the victims, portraying them as unreliable witnesses with questionable motives. They argued that the evidence was insufficient. They raised technical legal objections to various aspects of the case. And crucially, they engaged in what can only be described as an influence campaign, emphasizing Epstein's connections, his wealth, and his supposed importance to various powerful interests. The result, announced in June 2008, shocked the Palm Beach Police Department and FBI agents who had spent years building the case. Epstein would plead guilty to just 2 state charges: 1 count of soliciting prostitution and 1 count of soliciting prostitution from someone under the age of 18. That's it. No federal charges, no sex trafficking charges, no charges related to the dozens of other victims who had come forward. The plea deal came with a sentence of 18 months in county jail, of which Epstein would ultimately serve only 13 months. But even this minimal incarceration was a farce. Epstein was allowed to leave jail for 12 hours a day, 6 days a week, on what was called work release. He would be driven to a comfortable office in West Palm Beach, where he could conduct his business, make phone calls, receive visitors, and essentially live his normal life. Only at night would he return to his private cell in the Palm Beach County stockade. Even more extraordinarily, the plea agreement included a provision that granted immunity to any potential co-conspirators. This meant that not only would Epstein avoid serious punishment, but everyone who had helped him, everyone who had recruited girls for him, everyone who had facilitated his crimes, would also be protected from federal prosecution. It was a sweetheart deal of almost unprecedented magnitude. Palm Beach Police Chief Michael Ryder publicly accused the state prosecutor of giving Epstein special treatment. Detective Joseph Recarey, who had led the local investigation, expressed his disgust with the outcome. These were dedicated law enforcement professionals who had worked tirelessly to bring a predator to justice, only to see their efforts undermined by what appeared to be a backroom deal influenced by wealth and power. The victims were never properly consulted about this agreement, a violation of the Crime Victims' Rights Act. They learned about the deal from media reports, not from prosecutors. Many of them felt betrayed and abandoned by the justice system. They had been promised that if they came forward, if they testified, if they relived their trauma, justice would be served. Instead, they watched their abuser walk free after barely a year, most of which he spent in an office rather than a cell. Alexander Acosta would later defend his decision by claiming that he was told to back off, that Epstein belonged to intelligence. This cryptic statement has never been fully explained. What did it mean? Which intelligence agency? Why would that matter in a criminal case involving the abuse of American children on American soil? Acosta has never provided satisfactory answers to these questions. Regardless of the reasons, Acosta's career was not harmed by this controversial decision. In fact, he was later appointed by President Donald Trump to serve as Secretary of Labor, one of the highest positions in the federal government. He held this position until July 2019, when renewed media attention on the Epstein case forced his resignation. Even then, he left with a cabinet-level pension and his reputation largely intact among certain circles. The 2008 plea deal allowed Epstein to return to his life with minimal disruption. He registered as a sex offender, a legal requirement, but this did little to constrain his activities. He continued to travel internationally, continued to socialize with powerful people, continued to maintain his residences around the world. For all practical purposes, he had beaten the system. Fast forward to December 6, 2018. FBI agents and prosecutors in the U.S. Attorney's Office in Manhattan began a new investigation into Epstein. This came after the Miami Herald published a devastating series of investigative articles revisiting the handling of Epstein's case. The series, titled Perversion of Justice, focused partly on the role of Alexander Acosta and featured interviews with numerous victims who had never given up hope that real justice might someday be served. The Miami Herald investigation had a significant impact on public opinion. It wasn't just that Epstein had committed crimes, it was the systematic way he had been protected by the justice system. The reporting detailed how wealthy and powerful he was, but also how that wealth and power had been used to subvert justice. The series won numerous journalism awards and reignited intense public interest in the case. By July 6, 2019, the new investigation had progressed sufficiently for prosecutors in New York to take action. Epstein was arrested on new sex trafficking charges brought by the Southern District of New York, one of the most prestigious and independent prosecutorial offices in the country. These prosecutors concluded they were not bound by the earlier non-prosecution agreement made in Florida, as it was a different jurisdiction, and the alleged crimes included conduct that had occurred in New York. The new charges were serious and detailed. The indictment alleged that between 2002 and 2005, Epstein had sexually exploited and abused dozens of minor girls at his residences in Manhattan and Palm Beach. He had created a vast network of underage victims for him to sexually abuse, according to the charging documents. The indictment described how Epstein had paid victims hundreds of dollars in cash after each encounter and had encouraged them to recruit other girls. This time, there would be no sweetheart deal. The prosecutors made clear that Epstein would be held in jail pending trial, citing him as a danger to the community and a flight risk. With access to private jets, multiple international residences, and vast financial resources, Epstein could easily flee the country if released on bail. The judge agreed, and Epstein was remanded to the Metropolitan Correctional Center in Manhattan. For about a month, it appeared that justice might finally be served. Victims began coming forward again, many of them now adults, ready to testify. The case was being built methodically and publicly. And then, on August 10, 2019, Jeffrey Epstein was found dead in his cell. The official determination was suicide by hanging, but the circumstances immediately sparked intense speculation and conspiracy theories. Epstein had been placed on suicide watch after an earlier incident, but had been removed from that status. The guards who were supposed to be checking on him every 30 minutes had allegedly fallen asleep and falsified records. The cameras that should have captured his cell malfunctioned. A high-profile prisoner with information about numerous powerful people had died in federal custody under circumstances that seemed almost impossibly convenient for those who might want him silenced. An investigation by the Justice Department's Office of Inspector General later found serious failures at the facility, but concluded that there was no evidence of foul play. The guards were charged with falsifying records, a relatively minor offense. Many questions remained unanswered. How could so many failures happen simultaneously? Why had Epstein been taken off suicide watch? Who made that decision, and why? But Epstein's death did not end the pursuit of justice for his victims. Federal prosecutors in New York shifted their focus to his longtime associate and alleged accomplice, Ghislaine Maxwell. On July 2, 2020, Maxwell was arrested and charged with sex crimes. The indictment alleged that she had helped recruit and abuse Epstein's victims, sometimes participating in the abuse herself. Maxwell's background made her a particularly intriguing figure in this sordid story. She was the daughter of Robert Maxwell, a British media mogul who himself had died under mysterious circumstances in 1991. Educated at Oxford University, she had moved in elite social circles in both Britain and America. She had been romantically involved with Epstein in the early 1990s and remained closely associated with him for decades afterward. The depth of this corruption goes beyond anything we've covered so far. Make sure you're subscribed so you don't miss the final part, where we reveal the personal costs paid by the victims and the powerful people who continue to escape accountability. Drop a like if this reporting matters to you, and comment below with your thoughts on how justice failed. She's currently incarcerated at FCI Tallahassee, a low-security federal facility in Florida. She's appealed her conviction, arguing various legal errors, but her appeals have so far been unsuccessful. At 62 years old at the time of sentencing, 20 years represents a significant portion of her remaining life. Yet even Maxwell's conviction and imprisonment left many questions unanswered. She was one person in what appeared to be a much larger network. The documents now being released show communications with numerous other individuals who seem to have knowledge of Epstein's activities. Some appeared to have facilitated those activities. But Maxwell remains the only person besides Epstein himself to face criminal charges in connection with this case. This brings us to the communications revealed in the recent document dump. Among the 3.5 million pages are thousands of emails and text messages between Epstein and various people in his orbit. These communications provide glimpses into how his network operated and who was involved, but the strategic redactions ensure that the most important information remains hidden. One particularly revealing set of emails involves Steve Bannon, who would later become a chief strategist for President Trump. The emails from November and December 2018 show discussions about gifts. Specifically, Epstein's assistant Leslie Groff wrote about Apple Watch Hermes models, valued at $1,499 each, being given to Steve Bannon and his son Sean. The watches were described in detail: 44mm, space gray; stainless steel case, space black. Groff wrote that Jeffrey will give to Steve when he sees him next. Then, in January 2019, an email from a redacted name sent to Epstein confirmed: Steve has been given his Apple Watch. This was happening just months before Epstein would be arrested on new charges in July 2019.
Why was Epstein giving expensive gifts to Steve Bannon?
The timing is significant. In November 2018, the Miami Herald had just published its explosive series on Epstein. Public attention was intensifying. Earlier releases of Epstein files had already revealed that Bannon and Epstein had exchanged hundreds of text messages. According to those documents, Bannon was a key player in Epstein's long-shot effort to rehabilitate his reputation. Epstein apparently believed that Bannon, with his media savvy and political connections, could help manage the growing public relations crisis. The text messages showed Bannon advising Epstein on media strategy, discussing how to frame narratives, and planning responses to criticism. This was classic crisis management, except the crisis involved credible allegations of systematic child abuse. The revelation about the watches adds another dimension to this relationship. Were these simply gifts between acquaintances, or was there a transactional element? Was Epstein paying Bannon for his advice and assistance? Neither Bannon nor his representatives have provided a substantive explanation for these communications or the gifts. The redactions in the documents ensure that we can't see the full context of their relationship. Another set of documents reveals communications between Epstein and Howard Lutnick, who is currently serving as Secretary of Commerce in the Trump administration. Lutnick is the longtime CEO of Cantor Fitzgerald, a major financial services firm. After Epstein's initial conviction in 2008, Lutnick publicly stated that he would never be in the same room with Epstein again. However, the newly released documents show that Lutnick and Epstein corresponded through intermediaries in 2011 and 2012, years after that public disavowal. The communications reveal a relationship much deeper than Lutnick had previously acknowledged. While the specifics of these communications are often redacted, their very existence contradicts Lutnick's claim of complete separation from Epstein. A spokesman for the Commerce Department issued a statement saying that Lutnick had limited interactions with Epstein in the presence of his wife and has never been accused of wrongdoing. This carefully worded statement doesn't actually deny the communications revealed in the documents. It doesn't explain why Lutnick would maintain any contact with a convicted sex offender after publicly promising not to. It simply asserts that nothing improper occurred. This pattern repeats with numerous other powerful individuals. The documents show contact, but the redactions hide the substance. We can see that meetings happened, but not what was discussed. We can see that relationships existed, but not their true nature or purpose. It's transparency in form, but opacity in function. Perhaps the most significant name in the documents is former President Bill Clinton. An email from October 2009 from Society publicist Peggy Siegel to Epstein mentions a party at Ghislaine Maxwell's house. Siegel wrote, "Bill Clinton and Jeff Bezos were there. This was already after Epstein had pleaded guilty to solicitation charges involving a minor. Yet powerful people continued to socialize in circles that included him. Clinton has long maintained that while he knew Epstein and had flown on Epstein's private jet for work related to the Clinton Foundation, he had no knowledge of any criminal activity. Clinton's office has stated that he took a total of 4 trips on Epstein's plane in 2002 and 2003, all for foundation work, and that staff and supporters were always present. However, flight logs released previously showed Clinton's name appearing many more times than 4 trips would suggest. Some reports indicated over 24 flights on Epstein's jet. The discrepancy has never been adequately explained. Were some flights not counted because they were short hops between locations? Were Foundation staff members inaccurate in their accounting? Or was Clinton minimizing his association with Epstein? The newly released documents include deposition testimony from 2016, where Epstein was asked questions about Bill Clinton as part of Virginia Giuffre's defamation lawsuit against Ghislaine Maxwell. The deposition transcript shows a pattern that is both revealing and frustrating. Question after question about Clinton, and Epstein's response to each one. Fifth, he invoked his Fifth Amendment right against self-incrimination 172 times during this deposition. Why would Epstein need to invoke his Fifth Amendment rights when asked about Bill Clinton? The Fifth Amendment protects against self-incrimination, meaning it's used when answering truthfully might expose the person to criminal liability. If Epstein's relationship with Clinton was entirely innocent, what did he have to incriminate himself about? The fact that he used this protection so consistently when asked about Clinton raises obvious questions about what he was hiding. Clinton has never been accused of any wrongdoing in connection with the Epstein case. No victim has come forward with allegations against him. The documents released so far, despite thousands of pages mentioning him, do not contain evidence of criminal conduct. But the pattern of association, the frequency of contact, and Epstein's refusal to discuss it under oath all contribute to lingering questions and suspicions. The documents also reveal communications involving tech billionaire Elon Musk. While details are limited and often redacted, Musk's name appears in various contexts within Epstein's network. Musk has acknowledged meeting Epstein briefly at a party, but has stated he never had any business relationship or friendship with him. The documents don't contradict this, but they do show that Epstein had at least some level of contact with one of the world's wealthiest and most prominent individuals. Similarly, Bill Gates appears in the documents. Gates has admitted to meeting with Epstein multiple times, stating that he did so in the hopes that Epstein's connections might help with philanthropic fundraising. Gates has said he regretted these meetings and that they were a mistake in judgment. His ex-wife, Melinda French Gates, has spoken publicly about her discomfort with Gates's relationship with Epstein, and some reports suggest it was a factor in their divorce. In a recent interview on NPR's Wildcard podcast, recorded just after the latest document release, Melinda French Gates was asked about the renewed attention on her ex-husband's connections to Epstein. She expressed what she called unbelievable sadness about the situation. While she didn't elaborate extensively, her tone suggested the ongoing revelations remain painful and disappointing for her. Prince Andrew, the Duke of York and son of Queen Elizabeth, is perhaps the person most damaged by his association with Epstein. Virginia Giuffre publicly accused Prince Andrew of sexually assaulting her when she was 17, claiming that Maxwell had trafficked her to the prince. A photograph exists showing Andrew with his arm around Giuffre's waist, with Maxwell visible in the background. The photo was allegedly taken at Maxwell's London home. Prince Andrew gave a disastrous interview to the BBC in November 2019, attempting to address these allegations. He claimed he had no recollection of meeting Giuffre, despite the photograph. He offered bizarre explanations for why her accusations couldn't be true, including claiming that he couldn't have been sweating at a nightclub, as she described, because he had a medical condition preventing him from sweating, supposedly caused by adrenaline from being shot at during the Falklands War. Her 2015 defamation lawsuit against Ghislaine Maxwell was a turning point in the case. Although the lawsuit was eventually settled, it forced the release of thousands of pages of documents that revealed the scope of Epstein's network and the involvement of numerous prominent individuals. The deposition videos of both Giuffre and Maxwell, recorded in 2016, are among the materials included in the recent document dump. Watching these depositions now, knowing that Giuffre would take her own life less than a year before the full release of documents, adds a layer of tragedy to already difficult material. In the videos, Giuffre is composed but clearly affected as she describes her experiences. She names names, provides specific details about locations and dates, and maintains her story even under aggressive cross-examination. She comes across as credible and consistent, which is why her allegations had such impact. Maxwell, in contrast, appears haughty and dismissive during her deposition. She denies everything, claims not to remember convenient details, and shows little empathy for the women accusing her. At one point, when asked about the period when she was in a relationship with Epstein in the 1990s and 2000s, she becomes evasive and uncomfortable. The written transcripts of these depositions were released in 2020, but the video footage adds dimension to understanding both women's testimony. The decision to include these videos in the January 2026 release raises ethical questions. Did Giuffre consent to having her deposition videos made public? Did she know they might be released? Her lawyers have stated that she was assured certain materials would remain confidential. If that's true, then publishing the videos after her death represents another betrayal. Using her testimony while she's no longer here to control how it's presented or to defend herself against those who might attack her credibility. Giuffre's suicide note, which has not been made public, reportedly expressed exhaustion with the fight and frustration that justice remained elusive. Despite Maxwell's conviction, despite all the investigations, the vast majority of people who participated in or enabled Epstein's crimes have never faced any consequences. Giuffre had spent years hoping that speaking out would lead to accountability. Instead, she watched powerful people protect each other while she endured constant public scrutiny and character assassination. Her death devastated the community of survivors. Many spoke publicly about their grief and their fear that the most visible and vocal advocate for victims had been driven to such despair. Some expressed concern that it might discourage other survivors from continuing to speak out. The message seemed clear. Even when you do everything right, even when you tell your story and fight for justice, the system may still fail you, and the personal cost may be unbearable. Other survivors have continued the fight despite these setbacks. Danielle Bensky, the former teenage ballerina who found her confidential FBI interviews published online, has become increasingly outspoken since the January document release. Her journey from thinking the exposure was carelessness to incompetence to feeling it was deliberate reflects a growing suspicion among survivors that the failures in redaction were not accidental. Bensky has pointed out that it would be almost statistically impossible for hundreds of lawyers reviewing millions of pages over 60 days to consistently make the same type of error, protecting powerful people while exposing victims. If the errors were random, you would expect to see powerful names accidentally left unredacted and victim names accidentally protected at roughly equal rates. Instead, the pattern is overwhelmingly one-sided. Victims are named, powerful people are hidden. In interviews, Bensky has described the psychological impact of seeing her most traumatic experiences detailed in public documents accessible to anyone with an internet connection. She had spent 2 decades trying to move forward with her life, building a career, forming relationships, creating distance from what happened to her as a teenager. Now, anyone who knows her name can Google it and find explicit descriptions of her abuse. Former classmates, professional colleagues, even casual acquaintances can access this information. The violation feels total and irreversible. It's one thing to share your story with investigators in a confidential setting, knowing it might be used to build a criminal case. It's another thing entirely to have those confidential conversations published for the entertainment and curiosity of millions of strangers. Bensky has described feeling like she's been assaulted again, this time by the government rather than by Epstein. Charlene Rochard, another survivor, has focused her criticism on the apparent protection of predators within the documents. In her statement to CNN, she emphasized that publishing images of victims while shielding predators represents a complete failure of justice. She argues that the system has once again prioritized the comfort and privacy of powerful men over the safety and dignity of the women and girls they victimized. Rochard has called for accountability, not just for Epstein and Maxwell, but for everyone who enabled them. This includes the people whose names are redacted in the documents, the co-conspirators who allegedly helped recruit victims. But it also includes the prosecutors who gave Epstein a sweetheart deal in 2008, the officials who allowed him special privileges during his joke of an incarceration, and now the Justice Department officials who botched the document release in ways that harm survivors. The attorney Brittany Henderson has taken legal action on behalf of multiple survivors. She sent a detailed letter to the judge who had presided over Epstein's case, documenting what she characterized as thousands of redaction failures affecting nearly 100 individual survivors. The letter provided specific examples of names, photographs, and identifying information that should have been protected but wasn't. Henderson has also been dealing with the Justice Department's broken promises about fixing these problems. She reported that on a specific Wednesday, the department assured her they would correct the redaction failures by noon. She and her clients waited, checking the website throughout the day. Noon came and went. The afternoon passed. Evening arrived. The victim's information remained publicly accessible. It wasn't until the next day that some documents began to be removed, and even then, the process was incomplete and haphazard. This kind of bureaucratic failure might be understandable in a different context, but here it's unconscionable. Every hour that victim information remains online is another hour of exposure, another hour when that information can be downloaded and distributed. The Justice Department's slow response suggests either incompetence or indifference, neither of which is acceptable when dealing with the privacy and safety of abuse survivors. The department's official responses have been defensive and inadequate. A spokesperson stated that DOJ takes victim protection very seriously and has redacted thousands of victim names in the millions of published pages. This is meant to sound reassuring, but it actually highlights the problem. If thousands of victim names needed to be redacted, and the department knew this, how did they fail to properly redact so many of them? The statement amounts to claiming credit for doing part of a job they should have completed entirely. Deputy Attorney General Todd Blanche appeared on multiple news programs attempting to defend the department's work. His explanation about the volume of documents, comparing it to 2 Eiffel Towers of paper, comes across as making excuses rather than taking responsibility. Yes, the volume was large. That's exactly why more care should have been taken, more resources allocated, more time spent ensuring the work was done correctly. Blanche's statement that the department immediately dealt with problems when victims or their lawyers reached out is particularly troubling. It suggests the department's quality control process relied on victims themselves identifying failures in the protection of their own privacy. Imagine any other context where this would be considered acceptable. Imagine a hospital publishing patients' medical records and then saying they'll fix any errors as soon as patients notify them of the breach. The department has also tried to shift some blame to technical issues. They claimed that some documents couldn't be uploaded for review due to technical problems, and materials in foreign languages posed challenges. These may be legitimate obstacles, but they don't explain the systematic pattern of protecting powerful people while exposing victims. Technical issues would cause random errors, not consistently biased ones. Moreover, the department had clear legal guidance about what should and shouldn't be redacted. The Epstein Files Transparency Act, while requiring release of documents, also specified that redactions should protect victim privacy. The law was clear. Transparency about Epstein's crimes and connections, protection for those he harmed. The department managed to follow half of these instructions while failing catastrophically at the other half. As we approach the end of this investigation, the pattern becomes impossible to ignore. A system designed to protect the powerful while sacrificing the vulnerable. Subscribe to support independent reporting that holds the powerful accountable. Like this video to help spread awareness, and share your thoughts in the comments about what real justice would look like in this case. Members of Congress who authored the transparency legislation have expressed their own frustration and disappointment. Ro Khanna and Thomas Massie sent a joint letter to the Justice Department requesting access to the unredacted files. As the people who wrote and passed the law requiring disclosure, they argue they have a right and responsibility to review the complete record to ensure the department complied with congressional intent. Their letter pointed out the inconsistencies in redaction, blanket approach in some areas, complete failures in others. They noted that the same document sometimes appears multiple times with different information redacted in each version, suggesting a lack of coordination or clear standards in the review process. They emphasized that Congress cannot properly assess the department's handling of the Epstein and Maxwell cases without seeing what was hidden and why. The request for congressional access to unredacted files raises its own complications.
If members of Congress are allowed to see the full documents, how will that access be controlled? Will they be able to share what they learn with the public? Will they be bound by confidentiality agreements? And if they can see the names of alleged co-conspirators, what will they do with that information? The political dynamics are complex, especially given that some of the redacted names likely belong to politically connected individuals from both parties. There's also the question of what happens next with the investigation itself. Deputy Attorney General Blanche stated on CNN that new charges against anyone are unlikely. He explained that in July 2025, the Department of Justice had reviewed the Epstein files and concluded there was nothing in them that would allow for prosecuting anybody. He then noted that they released over 3.5 million pieces of paper, which the entire world can now look at and see if they were wrong. This statement is remarkable for what it reveals about the department's attitude. Rather than conducting a thorough investigation and making prosecutorial decisions based on evidence, they're essentially crowdsourcing the analysis. They're inviting the public to review millions of pages and point out if prosecutors miss something. This is not how criminal justice is supposed to work. The department has professional prosecutors and investigators whose job it is to evaluate evidence and build cases. Outsourcing that responsibility to internet sleuths is an abdication of duty. Moreover, the claim that there's nothing in the files that would allow for prosecuting anybody seems difficult to square with the content of those files.
The draft indictment describes multiple unnamed co-conspirators who allegedly helped Epstein recruit and abuse minors. Email communications show people facilitating meetings between Epstein and girls. The statute of limitations may have expired on some offenses, and some potential defendants may have received immunity under the 2008 plea deal. But surely, not everyone who participated in this network is beyond the reach of prosecution. The reality is likely more complicated and more depressing. Prosecuting wealthy, powerful, well-connected people is difficult. They can afford the best legal representation. They have resources to fight charges for years. They have connections that can create political pressure to drop cases. And perhaps most importantly, building a case requires victim cooperation, and victims who have already been traumatized may be unwilling to endure the additional trauma of a trial, especially when they've been betrayed repeatedly by the justice system. This creates a vicious cycle. Victims see that coming forward often leads to more harm than good. They watch as their privacy is violated, their credibility is attacked, and their lives are disrupted, while perpetrators face minimal consequences. Rational calculations suggest that staying silent is safer. But when victims stay silent, predators operate with impunity. The system that should protect victims and punish offenders ends up doing the opposite. The documents themselves will likely be studied for years by journalists, researchers, and advocates, trying to piece together the full story of Epstein's network and the failures that allowed it to operate for so long. Some patterns are already emerging. Epstein cultivated relationships with powerful people in multiple spheres: politics, business, academia, science, entertainment. He donated money to universities and scientific research. He attended conferences and social events. He positioned himself as a philanthropist and intellectual, despite having no real credentials or accomplishments beyond making money. This positioning gave him legitimacy and access. People wanted his money, his connections, his private plane for international travel. They were willing to overlook warning signs, to explain away concerns, to give him the benefit of the doubt. And he used this access to create a protective network around his criminal activity. The more powerful people he knew, the harder it became for anyone to seriously threaten him. The 2008 plea deal represents the system at its worst. Federal prosecutors had the evidence, the authority, and the responsibility to hold Epstein accountable. Instead, they cut a deal that essentially let him walk. The explanation from Alexander Acosta about being told to back off because Epstein belonged to intelligence has never been verified or clarified. If true, it suggests a government actively protecting a sexual predator for reasons of supposed national security. If false, it's a convenient excuse to avoid taking responsibility for a terrible decision. Either way, that decision had consequences. Epstein was emboldened. He continued his activities. More girls were victimized over the next decade. Victims who had cooperated with the original investigation felt betrayed and were less likely to trust law enforcement in the future. And Epstein himself learned that he was effectively above the law, that his wealth and connections made him untouchable. This lesson held until 2019, when the Miami Herald's reporting forced a reckoning. Even then, Epstein escaped final accountability through death. Whether his suicide was the result of negligence, incompetence, or something more sinister may never be definitively proven. The official investigation found serious failures, but no evidence of foul play. The conspiracy theories persist because the circumstances were so suspicious, and because there were powerful people who had strong incentives to see Epstein silenced. Ghislaine Maxwell's conviction and imprisonment provides some measure of justice, but it also raises questions. She was clearly Epstein's partner in his crimes, but was she also, in some ways, Another person he manipulated? She was involved with him romantically when she was young, and their relationship evolved into something complex and disturbing. This doesn't excuse her actions or diminish her responsibility, but it complicates the narrative. The victims who testified at Maxwell's trial showed remarkable courage. They had to face their abuser in court, recount traumatic experiences in front of strangers, and endure cross-examination designed to discredit them. They did this knowing that Epstein was already dead, that Maxwell might be the only person to ever face consequences, and that the broader network would likely remain protected. They did it because they believed in justice and accountability, even when the system had given them little reason to maintain that belief. The jury's decision to convict Maxwell on 5 of 6 counts validated those victims and their testimony. It sent a message that at least some accountability is possible, even for wealthy and connected defendants. But the sentence of 20 years, while substantial, also highlights what was lost when Epstein died. He should have faced trial, should have been forced to answer for his crimes publicly, should have served decades in prison. Instead, he took his secrets to the grave. The document release in January 2026 was supposed to provide transparency and closure. Instead, it has created new trauma for survivors while still hiding the most important information. We know that powerful people were connected to Epstein. We know that some of them maintained those connections even after his conviction. We know that people helped him recruit and abuse victims. But we don't know who most of these people are, and it appears unlikely they'll ever face consequences. The FBI diagram showing the network of victims demonstrates the scale of what Epstein created. Dozens of girls connected through a web of exploitation, each one recruited to recruit others, creating an ever-expanding circle of abuse. This wasn't opportunistic crime. It was systematic, organized, and sustained over years. It required infrastructure, planning, and the participation of multiple people. Yet Maxwell is the only living person in prison for it. The files show communications spanning decades, involving hundreds of people in Epstein's orbit. Some were clearly aware of his criminal activity. Others may have suspected but chose not to ask questions. Still others might have been genuinely ignorant, interacting with Epstein in professional or social contexts without knowledge of his dark side. The redactions make it impossible to distinguish between these categories for most individuals mentioned in the documents. This ambiguity serves the powerful. When everyone is vaguely implicated but no one is specifically accused, people can claim innocence without having to prove it. They can say they didn't know, that their interactions were innocent, that they cut ties once they learned the truth. And without access to the full, unredacted documents, it's impossible to verify or challenge these claims. The system has created plausible deniability as a default. For the survivors, this is another form of injustice. They know who was involved. They told investigators. Their testimony is in those redacted documents. They watch as the same people who hurt them or enabled their abuse continue with their lives and careers, protected by black rectangles on government documents. The message is clear. Your trauma matters less than their reputations. The psychological impact on survivors of this entire process cannot be overstated. Many have described feeling like they're being victimized over and over again. First by Epstein and his network, then by a justice system that failed to protect them or hold offenders accountable. Then by media coverage that sometimes sensationalized their suffering or questioned their credibility. And now by a document release that exposed their identities while protecting their abusers. Some survivors have had to change their names, move to new cities, or withdraw from public life because the document release made them identifiable and findable. They receive messages from strangers, some supportive, but others cruel or even threatening. They have to explain to employers, partners, or children why their names appear in news articles about a sex trafficking case. The impact extends to every aspect of their lives. Mental health professionals who work with trauma survivors have expressed alarm at the Justice Department's failures. Trauma recovery often involves regaining a sense of control and safety. Having your most painful experiences published without your consent, having your privacy violated by the institution that promised to protect you, destroys that sense of control. It can trigger relapses, depression, anxiety, or even suicidal ideation. For Virginia Giuffre, these pressures may have contributed to her decision to end her life. The advocates and attorneys representing survivors have called for systematic reforms. They want clear protocols for how victim information is handled in document releases. They want victims to have a say in what information about them becomes public. They want accountability for officials who fail to protect victim privacy. And they want prosecutors to pursue everyone involved in Epstein's network, not just the most visible figures. Some have proposed legislation that would strengthen victim protections in cases like this. Ideas include requiring victim consent before releasing identifying information, creating harsher penalties for officials who negligently expose victim data, and establishing independent review processes to check government work before documents are released. Whether any of these proposals will be adopted remains to be seen. The broader cultural conversation about Epstein has also evolved. Initially, when his crimes first became public in 2006, there was skepticism about the victims. People questioned why teenage girls would go to a strange man's house, why they would return repeatedly, why they didn't report the abuse immediately. This reflected common misconceptions about how trafficking and grooming work. Over time, as more information emerged and more victims came forward, understanding grew. People began to recognize patterns, how Epstein targeted vulnerable girls, often from troubled backgrounds, how he used money and gifts to create a sense of obligation, how he normalized the abuse gradually, how he isolated victims and made them feel they couldn't escape or speak out. The trial testimony and released documents have educated the public about the realities of sexual exploitation. But there's still a troubling tendency to focus on the famous names rather than the victims. News coverage of the document release often led with headlines about Trump, Clinton, or Prince Andrew, relegating the victims' stories to secondary status. This reflects what the survivors already know. Society is more interested in scandal among the powerful than justice for the powerless. The question of what happens next remains open. The documents are now public, and anyone can access them through the Justice Department website. Journalists and researchers will continue analyzing them, potentially uncovering new connections and information. Congressional investigations may pursue some leads. Civil lawsuits from survivors against Epstein's estate and potentially others could continue for years. But criminal accountability for the broader network seems unlikely. The statute of limitations has expired on many potential charges. The 2008 plea deal granted immunity to unnamed co-conspirators. Witnesses like Epstein are dead, and Maxwell has no incentive to cooperate with prosecutors. Building new cases would be difficult and resource-intensive, and the political will may not exist. For the survivors, justice may have to come in forms other than criminal prosecution. Some have found healing through speaking publicly and advocating for other victims. Some have pursued civil litigation to obtain financial compensation and public acknowledgement of what was done to them. Some have channeled their experiences into work fighting human trafficking and supporting other survivors. These paths don't replace criminal justice, but they offer alternative routes to processing trauma and reclaiming power. The Epstein case will likely remain a subject of fascination and investigation for decades. It touches on fundamental questions about power, justice, and accountability in American society. It reveals how wealth can corrupt institutions designed to protect the vulnerable. It demonstrates how networks of privilege and influence can shield wrongdoing from consequences. And it shows how victims of the powerful often end up victimized again by the systems that should protect them. The 3.5 million pages of documents represent both revelation and obfuscation. They confirm what many suspected, that Epstein operated with help from others, that powerful people were connected to him, that the justice system failed repeatedly to hold him accountable. But they also obscure the most important details, protecting those who might still face consequences if the full truth emerged. History will judge this moment.
Future generations will look at these documents and the decisions made about what to reveal and what to hide. They will see a society that had the evidence to hold powerful predators accountable, but chose to protect them instead. They will see a government that promised transparency, but delivered selective disclosure. And they will see survivors who deserved justice, but received betrayal. The legacy of Jeffrey Epstein is not just the crimes he committed, but the system that enabled him. Every person who helped him find victims, every official who gave him lenient treatment, every prosecutor who cut him deals, every editor who spiked stories about him, every friend who looked the other way, they are all part of this legacy. And now, every official who failed to properly redact victim information while hiding perpetrator names has added to it. The survivors have shown extraordinary strength and resilience. Many continue to speak out, to fight for justice, to support each other. They have refused to be silenced or shamed. They have challenged powerful institutions and demanded accountability. In many ways, they have already won a moral victory, even if legal justice remains elusive. Their courage has brought darkness into light, even if some still hide in the shadows. The fight continues. More documents may eventually be released with better redactions. Congressional investigations may uncover additional information. Civil lawsuits may reveal what criminal proceedings did not. And most importantly, survivors will continue telling their stories, ensuring that the focus remains on the real victims and the real crimes, not on the famous names and political intrigue. The January 2026 document release was supposed to mark the end of secrecy in the Epstein case. Instead, it marked another chapter in a long story of justice delayed, denied, and perverted by power. The full truth remains hidden, protected by black rectangles and legal privileges. But the survivors know that truth. They lived it. And they will not let the world forget, no matter how many powerful people would prefer that everyone move on and stop asking uncomfortable questions about who knew what and when, and why so few have faced any consequences for enabling one of the most prolific sexual predators in modern American history.